same people involved here, State versus Jackson. Now, I know we are about 5 minutes early, so I don't know if you're expecting anybody else, else we can proceed. Court can accommodate your schedules.
I'm ready when you are.
Okay, all right, then let's proceed. Same rules, 15 minutes each, and you may reserve up to 5 as the appellant. Thank you.
May it please the court, I'm still Michael Stepanek. I represent defendant appellant Darrel Jackson. Mr. Jackson has a cocaine case, this court is aware. The trial court found him guilty of trafficking, found guilty of trafficking and possession of drugs with major drug offender specifications. It was based on evidence found in his residence. And again, there was lab reports done. Elizabeth Doyle from the Lorain County Crime Lab came over and testified as to the identity of the controlled substance, and she had identified cocaine. She had also identified levamisole, which is a cutting agent. There was, again, we believe that the state of Ohio, the legislature, rightly or wrongly, whether they knew what they were doing, they did change the, in order to cure the disparity between trafficking or possession of cocaine, powder form, and crack cocaine, they got rid of the bulk amount language regarding crack cocaine, so now it's all just considered cocaine. For whatever reason, in the penalties section, the sole drug which you need to prove the weight of is cocaine, because the legislature does not say if the amount of the drug involved equals or exceeds X amount of grams, and there it says X amount of grams of cocaine. Why that's there, it's either what they intended or it's superfluous. There's a lot of case law saying the legislature doesn't just throw words in there. So I think that's what they intended. Whether they intended the result, I don't know, but they intended that to be the law. I think, again, in this case, even if this court believes that you could weigh the entire mixture, compound, or substance, or I'm sorry, preparation, there was zero testimony elicited from the lab technician that this was a mixture, a compound, or a substance. What the lab technician said, again in this case, like Mr. Hamilton 2 cases ago, is that you've got a certain amount of cocaine. She can't even tell you how much of that sample is cocaine, and levamisole. What did the rest of it test as? I have no idea. Did you test just one section or the entire sample? I just tested one section. It appeared visually to be homogeneous. Well, does that visual homogeneity, I think that's the word, translate to chemical homogeneity? No, but I just assume it is. So Mr. Jackson is currently serving an 11-year prison sentence because less than 1/10 of a gram, I think Ms. Doyle said, was tested and determined to be cocaine. Even if the trial court were to have said, I'm going to weigh or use the entire mixture, preparation, substance, there's no testimony from the lab technician, no testimony from any of the police officers that this was a mixture. Is it possible that, and you're talking,
It tested positive for cocaine.
correct,
It could be pure cocaine, or it could be a mixture of cocaine and some cutting agent.
we know it's not pure cocaine because something else was identified as being in there.
So I don't understand your statement that we don't know what's in it.
Well, is it a mixture?
Well, it's obviously a mixture if it comes back with cocaine and some other cutting agent.
But what does mixture mean? I think that's the point.
Well,
You could have, and we're talking, Judge, we're talking, and I'm not trying to, we're talking really tiny, like grains of sand, or, that's the, is it possible that you have a drug dealer, let's say, or a drug user, who's got a big old bag of cutting agent, and he's walking by one day and, actual cocaine drops in there. Maybe he's still got some left over on his hands, and the lab tech takes something you can't even really see, identifies that as cocaine and then just says, I'm gonna assume the rest. Is that a mixture? I don't think it is. That's why I think the state, it was interesting, the Lorain County Crime Lab, they'll only take one little section, that's it. I had the opportunity to watch this Gonzalez oral argument a couple months ago, and I recall the prosecutor there, because the Ohio Supreme Court had a question like, wait a second, so you guys just take, no, we're testing from all different areas. We're trying to see whether it's kind of, so even if you guys don't know if it's a mixture, we're testing to see if it's a mixture because we're testing different areas of the substance, not just one little part.
Under your hypothesis here, that there was a big giant bag and just a tiny bit fell in, how would you test? I mean, would you spread it all out and see what portion of this giant acre of cut had a teeny tiny bit of cocaine? How would you?
If it was an acre of cocaine, we're
I mean,
in
if
federal court.
you spread it out really thin, like one molecule thin, the cocaine molecule, how would you sort that off? But what area comprised pure cocaine as opposed to this entire acre of one molecule thick cocaine? How are you gonna figure that? I mean, how do you do that?
A couple different answers to that same question. First of all, it's the state's problem, because I think that's what they're directed to do. Second thing is, and this is kind of simple, I think, let's say that you've got a situation where you've got this bag of cocaine or a pile of cocaine. I don't know, see Scarface, what was sitting on his desk?
Pure cocaine or just
Well,
a mixture,
who knows?
compound, or preparation of cocaine?
well, let's just say there's a big pile of what the state suspects is cocaine, and they test one part, there's some cocaine in that part. Well, they can test the other 99,000 different parts, and there's no cocaine whatsoever. And that's what Ms. Doyle said is certainly possible in this case. So, again, I got two different arguments. First is, they got to prove the actual amount of cocaine. And do I know the answer to that specific question? How you test it? No. But the lab tech that works across the street that the state brought in says it's possible. How they do it, I don't know. I've never seen it done. I know that the lab tech in this case that was called by the state of Ohio said it's possible, we just don't do it.
Let me ask you another hypothetical question.
Yeah.
Hypothetically, that giant bag of whatever it is would sell for $1 million on the street, but only 5% of it contains actual cocaine. So that means you only can confiscate 5% of the proceeds from the sale of that stuff? Or, I mean, how would you figure out how much money they got to keep because they were selling Bamisol as opposed to just selling cocaine?
Well, even if it's a counterfeit controlled substance, it's still a crime, it's still forfeit all of it, I would argue. And but that's what the Detective Chris Colon testified in this case. I said, Chris, what's the cheapest amount of cocaine deal you've ever seen? He's like $5. And I said, so okay, is it possible? And I think this was this case. I know maybe Mr. Hamilton today too. And he says, well, yeah. I said, so you could have then, I don't know, a bunch of other cut, and for $5 investment, you could have 1,000 grams of cocaine. He goes, well, no one would buy it. I'm like, well, but I said, so that means it's cocaine? He goes, well, no, but, yeah, it's cocaine because it's mixed. And I'm like, but you guys didn't test. In this case, you didn't test to see whether it was even mixed. So the state's going to get up and say, well, this was a mixture, a compound, this and that. Why did the lab tech not testify to that? There's no testimony to that. It's just, we want to just assume that, well, it was a mixture, or compound, or derivative, or preparation. But there's no testimony to that. There's not a single word from the lab tech's mouth saying that. And that's why I think for that reason, even if the state's going to be held to the entire compound mixture, there was no evidence there was a compound mixture or anything like that. And the lab tech's going to say, I only tested one part. I would only test different things if they were different colors. And I'm going to reserve the next 2 minutes maybe I have left. I forgot to reserve
We
the
have actually over 5, but we'll say 5 for you. Thank you.
Thank you.
May it please the court, I also am still Elizabeth Berg on behalf of Appellee of the State of Ohio. Darrel Jackson was indicted by the Lorain County Grand Jury on November 26, 2014. He was charged with count 1, trafficking in cocaine, a felony of the first degree. Count 2, trafficking in cocaine, a felony of the first degree. Count 3, trafficking cocaine, a felony of the first degree. With specifications on those. Count 4, possession of cocaine, a felony of the first degree. Count 5, trafficking in cocaine, a felony of the second degree. Count 6, trafficking in cocaine, a felony of the second degree. Count 7, tampering with evidence. Count 8, having weapons of learner disability. Count count 9, possessing criminal tools, and count 10, drug paraphernalia offenses. Mr. Jackson entered pleas of guilty to counts 1 and 2 and counts 5 through 10. He maintained pleas of not guilty on counts 3 and 4 and tried those to the bench. In this case, he was found guilty on those charges and presently appeals. As this court is aware, the assignments of error presented here are based upon the pending decision by the Ohio Supreme Court in State v. Gonzalez, 2015-0384. Mr. Jackson presents this court with 2 assignments of error, and each will be addressed in turn. His first assignment of error is that the trial court erred in convicting him based upon insufficient evidence. As to sufficiency, criminal 29A states that the trial court shall order the entry of a judgment of acquittal if the evidence is insufficient to sustain a conviction on such offense or offenses. However, if the record demonstrates that reasonable minds may reach different conclusions as to the proof of material elements of a crime, a trial court may not grant a criminal rule 29A motion for acquittal. The relevant inquiry here is whether, after viewing the evidence in a light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime proven beyond a reasonable doubt. Going back to what this court has previously heard, under the definition of cocaine in 2925.01x, cocaine means any of the following: cocaine salt, isomer, or derivative. Second part is coca leaves or a salt compound, derivative, or preparation of coca leaves. 3, a salt, compound, derivative, or preparation of a substance identified in Division X1 or 2. Also, in the revised code, under the possession statute as well as the trafficking statutes at C4, it says if the drug involved in the violation is cocaine or a compound mixture, preparation, or substance containing cocaine, whoever violates Division A of the section is guilty of possession of cocaine. Mr. Jackson then also cites to C4F of the possession statute and C4G of the trafficking statute, wherein it says if the amount of the drug involved equals or exceeds a certain amount of cocaine, then there is an increased penalty that goes along with that. However, as cited, cocaine itself already contains the word compound in its definition. When citing to C4 possession of cocaine, the drug involved is either cocaine or a mixture, compound mixture, preparation, or substance containing cocaine. Therefore, whatever the drug involved is, it can be a compound mixture or preparation containing cocaine, and that would still be sufficient. In this case, after officers went to 413 Augusta Avenue in Lorain, they found bags that were suspected to contain cocaine. Elizabeth Doyle of the Lorain County Crime Lab testified there was a bag containing 5 baggies of white powder which were submitted to the lab. The total weight of the 5 baggies was 137.89 grams. 4 of the 5 bags were tested per lab policy. All 4 of them contained cocaine and lobamycol. The contents of the 5th bag appeared to be the same as the other 4 bags. Also submitted to the lab for testing was
But it wasn't tested.
excuse me?
The 5th bag was not tested.
That's correct. The 5th bag was not tested. However, in the record, State's Exhibit 51 was the lab report from the Lorain County Crime Lab, and it provides the weight in grams of each of the bags. And the first bag is 27.21 grams, which was tested. The second bag is 27.69 grams, which was tested. The third bag, 27.8 grams, which was tested. And the 4th bag was 27.53 grams, which was tested. So together, those 4 bags that were tested that came back as cocaine and lobamycol is over the 100-gram limit pursuant to the statute. The 5th bag, which was not tested, was 27.66 grams. Additionally, also submitted to the lab for testing was a specimen weighing 38.2 grams that tested positive for cocaine and lobamycol as well. The possession and trafficking statutes have undergone changes, clearly. When the law was revised in 2011 by House Bill 86, the distinction between powdered cocaine and crack cocaine was removed. The legislature appears to have overlooked redrafting the language of C4 of the possession and trafficking statutes to mirror the language of the other drugs, and instead held over much of the same language that was in effect when the statute was designed to delineate between powder and crack cocaine. Purity has never previously been required prior to the 6th District cases of State v. Gonzalez and State versus Sanchez. The state outlined numerous cases in its brief where that has never been required, and other things contained within the drug involved along with the cocaine have been weighed in total for purposes of the statute. Again, Jackson is relying upon State versus Gonzalez and State versus Sanchez, not binding precedent on this court, both of which are pending a decision from the Ohio Supreme Court. Gonzalez, which was argued in February, and we are awaiting a decision on that. Drugs containing cocaine, as RC 292511C4 recognizes, are traditionally a compound, mixture, preparation, or substance containing cocaine, and crack cocaine always is. It's challenging, particularly challenging for drugs containing powder cocaine, and all but impossible for drugs containing crack cocaine to determine the amount of pure cocaine contained within that drug. As argued by Mr. Jackson, that Elizabeth Doyle made it clear that the Lorain County Crime Lab does not have the ability to do such testing at the present time. From a statutory construction standpoint, a court cannot pick out one sentence and dissociate it from the context, but must look to the four corners of the enactment to determine the intent of the enacting body, and statutes must be construed, if possible, to operate sensibly and not to accomplish foolish results. Both of those statements are from the Ohio Supreme Court. Here the defense wants the word cocaine to supplant the essential element of the offense, in which the word cocaine is used to describe the drug involved, which can be cocaine or a compound, mixture, preparation, or substance containing cocaine, under both the possession and trafficking statutes. Again, the magic words of mixture, compound, preparation may not have been used. However, as Judge Whitmore mentioned, if it's cocaine, if it's a controlled substance, and something else, the common meaning of the word mixture would be that it's more than one thing contained therein, and therefore would be a mixture containing cocaine. As to Mr. Jackson's analogy of a pile of cocaine on the table, if you test one portion of it and it comes back as cocaine and something else, let's say you test another portion, it comes back with levamisol. You test another portion, it comes back with cocaine versus cocaine and levamisol. In any of those circumstances, that pile still contains cocaine. That pile is still sufficient to be cocaine underneath the statute, as it is a mixture or preparation containing cocaine, and therefore would be sufficient for a possession or trafficking, if that were the case, charge and conviction.
And so for the purpose of the degree of the offense, you would then collect that pile and weigh the entire pile?
Yes, that is correct. Assignment of error 2 that Mr. Jackson raises, the trial court's entry of conviction was against the manifest weight of the evidence. The appellate court must review the entire record and weigh the evidence and all reasonable inferences, consider the credibility of witnesses, and determine whether, in resolving conflicts in the evidence, the trier of fact clearly lost its way and created such a manifest miscarriage of justice that the conviction must be reversed and a new trial ordered. It's only to be invoked in extraordinary circumstances, and the court sits as the 13th juror. This is only implicated when the fact finder clearly lost its way. In this case, the state presented ample evidence to prove that the trial court that Jackson was in possession of and was trafficking in cocaine in an amount exceeding 100 grams from his home at 413 Augusta Avenue in Lorain. Once officers entered the home to execute the search warrant, they began searching the premises. In the kitchen, on the countertop, white powder was found and field tested positive for cocaine. They made contact with Jackson in an upstairs bedroom with his young child, waking up from being asleep. In the home, they found a pair of jeans with U.S. currency in the pocket. There was a firearm found underneath the mattress. In the master bedroom where Jackson and the child were located, 2 cell phones were also found on top of the mattress. There was a vent hole in a child's upstairs bedroom, and once the vent was removed, officers found U.S. currency and a large amount of cocaine and a scale in a bag. Pyrex jars were found in the kitchen, which can be used by someone preparing cocaine. A grinder was found in the kitchen. Also found in the kitchen was a bag of crack cocaine. There was a baggie and a piece of a white chunky substance. All items were field tested and came back with a positive reaction for the presence of cocaine. A white substance was found throughout one of the kitchen drawers that indicated it was cocaine. A cocaine press was found. A piece of paper with white residue was found, as were plastic baggies containing white chunky or white powdery substances, and a brown bag containing white powder, all of which were sent to the lab. Police gathered several items of evidence in the form of Pyrex jars with residue, a metal grinder, a metal pan with white residue, a digital scale, an iPhone used to coordinate deals with the CI, an ID card for Jackson, which was found in the southwest bedroom in his pants pocket, a hydraulic press. There was also a closet area in the child's bedroom that had a panel covering an access way. Inside the cubbyhole, Sergeant Camarillo found a bundle of currency and a brown paper bag with a white object protruding from it. There were several bags of cocaine found within the brown bag. Sergeant Camarillo classified it as a significant amount of cocaine. Camarillo further clarified that he considers a significant amount of cocaine anything that would be indicative of someone trafficking. The amount of drugs found indicate to Camarillo an upper-level drug dealer. Again, Elizabeth Doyle testified as to her process in testing the substances, that there were 2 different substances that she weighed. Some of the small substances came back just with benzocaine and caffeine and no controlled substance, and then the larger amounts, as previously discussed, came back as cocaine and levamisole. All 5 bags' contents appeared to be the same, and the 4 all tested for the same contents, not necessitating testing of the 5th bag. Based upon all of those facts and what was presented to the trial court, a manifest weight of the evidence challenge cannot be successful based upon what was provided to the trial court. For the foregoing reasons, the state asks this court to uphold the trial court's decision and affirm Jackson's conviction and sentence.
Thank you. You have your 5 minutes remaining.
Thank you. So, again, if you're baking a cake and you put the flour in and then the egg, the next direction is mix it. And the state's saying that we put the flour in, you put the egg there, that's a mixture. Don't go any further. That's what a mixture is. You mix it together. Dairy Queen made a lot of money because a Blizzard is a mixture of ice cream and delicious treats. Not because they're separate. No one's going to buy that. And it's relevant, and I'm not trying to be funny, but it's relevant because there's no proof of that. The state says, well, compound's right there. Well, we're talking about chemicals, we're talking about controlled substances. There's no definition of compound, but a dictionary definition of a chemical compound, a pure substance composed of 2 or more elements whose composition is constant. Yeah, there was no testimony about that at all, but the state's asking the 3 of you to do the work and say, just assume a compound, assume a pure substance composed of 2 or more elements whose composition is constant. There's no proof of it, but it sounds good and it'll help the state win its case. And I think that that's...
What's the legal definition of a substance?
How's that?
What's the legal definition of a substance?
Well, I've got the... I would think a substance would be a thing off the top of my head. I don't know if we have one. I don't know of a statutory definition of a substance, but I know that there's none compound, and the plain ordinary compound, chemical compound, would be what I just advised. So, what Ms. Doyle testified to, I'd ask, when you get something in the lab, a bag of powder, do you mix it up before you test it? And she says, well, if it's in the same sort of bag, it's put onto the scale, and then I look at it while weighing it to see if it's homogeneous, to see if it all looks the same. So if there's a clump of brown powder and a clump of white powder, a sample would be taken from each. It says, okay, do you know, based on your testing of these substances over the years, whether cutting agents in cocaine can look exactly the same? She says they could. So you may have a mixture that is visually homogeneous, but not chemically. She says that's correct. So you've got something where something next to another thing looks the same, but she'll say chemically it's not the same, it's not a mixture. These things don't exist next to, they exist next to each other, but not intertwine with each other. And there's a reason that this legislature has a mixture in there.
Mixture means a gathering together of different things. I mix a cake and I have flour and sugar. Now, granted, flour and sugar don't look alike, but that's a mixture.
I think if they're next to each other, no. I think if you mix them, then yeah.
Well, we're talking about substances that are mixed. We're not talking about them in separate files.
Well, that's the whole point, is that Elizabeth Doyle, the lab tech, she never testified it was mixed. And again,
Well, okay, with crack, we know it's a mixture of something, but it's all in a solid,
Okay,
all right? So if it tests positive for the compounds that create crack,
correct.
you weigh it, and that's the bulk amount, correct?
Bulk amount does not exist for crack
Okay,
anymore.
well, that's what it weighs.
That's what it
And
weighs.
the statute talks about weight, right?
Correct.
So you put the cocaine in with the cutting agent, like I would put the flour and the sugar together, they granted in that example look different.
Sure.
But I take it that when you talk about the cutting agent, whatever it is, and the cocaine, they do not look dramatically different.
According to Ms. Doyle, yes.
Okay.
And that's why I asked her, I said, when you only include a single controlled substance on a lab report, is that your representation that 100% of that substance is what it is? Meaning if you have a lab result that says, I find cocaine, does that mean that 100% of it is cocaine or only what you tested? She says, only what I tested.
So you're saying that you get a bag of something, you weigh it, you know how much it weighs.
Correct.
Then what you need to do is spread it out and take a sample here, a sample there, and you have to take multiple samples of what's in that bag.
I think that you should in order to determine that it's a mixture.
But does the statute require that?
Yes.
It
Because
requires multiple tests of the mixture?
I think it requires that from an evidentiary standpoint to determine whether it is a mixture. Because the state is saying, well, if the Court of Appeals agrees with the state, my point is, even if Gonzalez is upheld or reversed by the Ohio Supreme Court, and it says, you just weigh the whole thing. My argument is, the state wants to say, well, mixture compound, there's no evidence of that. In order to determine whether it's not cocaine next to a cutting agent, you should test more than one sample of it, because the lab tech in this case says that she says the cocaine is only what she tests, and I said, and you just assume the rest of it is cocaine, and she says yes. So I don't think the state can say there's a mixture without testing for more than one spot.
Well, they knew there was a mixture because both the cutting agent and the cocaine was identified.
Which means that they were both together, but Ms. Doyle says it's possible that they...
When you say together, they were not chemically fused, they were separate chemical molecules.
Sure.
Yeah, and we have a bag, and it is not humanly possible to look at the molecules and say, this one is the cutting agent and this is the cocaine.
To look at them, no.
You're saying that you can't just test one spot in a bag, you've got to test maybe 15 spots in the bag.
More than one would be cool. I mean, if you're talking about 11 years of someone's life to determine that it's a mixture, you test just that one little spot, and the lab tech, their expert says, yeah, the rest of it could all be fake. Well, then why don't you test the rest of it? Nobody told me I should. I mean, that's what we're up against here. And, you're being asked to assume it's a mixture with no evidence, assume it's a compound with no evidence, assume it's a preparation with no evidence, no testimony.
Assume it's a substance, there's no evidence, no testing.
Well, I mean, I think anything's a substance. I'm a substance, I would guess. I'm a substance.
Also a mixture of a lot of different things.
I don't know. I mean, that's a little bit more complex than lambasol and cocaine, I think.
And we'll have to leave that to the discussion maybe at another time, as to what the defense attorneys made up on.
Don't answer that. Thank you.
Nobody's going to see it.
Well, anyway, thank you for your presentations to the court. The court will take the matter under advisement and issue a written opinion that will be sent to you, as well as will